In the previous lesson, what we did was talk about Austinian positivism, some of the major component aspects of Austinian positivism, a basic recap of some of the early and traditional concepts within legal positivism, and then the major critique of John Austin's legal positivism, which is, of course, his reaction to and relationship with international law. Given the fact that, according to Austinian positivism, law is derived from the sovereign, whatever that sovereign may be, and given the fact that international law is made without the existence of some kind of international sovereign, it's suggested that therefore international law is not law. It may still exist, but it is not law in the way that we understand domestic law, for example. Well, what we're going to do in this lesson is go into far more detail looking at Austin's definition of law. We're going to talk about some of the elements of Austinian positivism. We'll talk about some of the key components of it and some of the very specific elements of it as well. So far, we have been examining the nature and origins of legal positivism, the jurisprudential theory of legal positivism. We know already that legal positivism is something that has developed from the sort of mid to late 1800s with people like Bentham and people like Austin, and then developed further post-Second World War, and now we have some of the more modern legal positivists, people like H.L.A. Hart, and then you have the sort of Hart and Dworkin debates that were had in relation to positivism and jurisprudence more generally. But for now, let's just focus on some of the classical theories, some of the traditional legal positivists. The origins are in the work of John Austin. So given the fact that what we did in the last lesson was essentially delineate between what is natural law and what is legal positivism, I want to actually get into some of the specifics relating to Austin's definition of law itself. So we talked about where law comes from as part of Austin's theories of law, but what about his definition of law? So what then actually is law according to legal positivism? So according to Austin himself, law is, quote, established in an independent political community by the express or tacit authority of its sovereign or supreme government. That is the conclusion that Austin derives when he thinks about what law actually is. And this is interesting because we're talking about the express or tacit authority of its sovereign or supreme government. Remember, the last lesson we focused on the fact that law is derived out of the sovereign, according to John Austin. And this is obviously different to the fact that there is an inherent link between law and morality, according to natural law theorists. And so you establish law either impliedly or expressly through the authority of the sovereign or a supreme government. And this gives rise to what Austin describes as sovereign command theory. This is the theory that law derives out of the sovereign authority of the state. And it's a simple extension of the thesis of Austinian positivism. It's a simple extension and logical conclusion that you can derive out of thinking about what John Austin believes in terms of his understanding of legal positivism. In its simplest form, it is the sovereign command theory is the proposition that the law is at the command of the sovereign. Okay, as the name suggests, sovereign command theory, it suggests that the sovereign is in command of the law itself. Okay, and this again forms a basis of this particular quote, this particular passage, the idea that law is established in an independent political community, either expressly or impliedly, by the authority of the sovereign. It implies that, therefore, it is the sovereign that is in command of the law, the proposition that law is at the command of the sovereign. And with that being said, and given that fact, it also is extended. Then the next extension is that there are no external influences which impact on law except through that of the sovereign. Not only is sovereign command theory telling us that the sovereign has command of the law, but it is telling us that only the sovereign has command of the law. There is no other external influences on the law. And the key distinction delineation that we always derive here and we always point to is the idea of morality. Morality is not something that is influencing the law and the creation of the law. Only through the sovereign is their influence and creation of law. That is the point of sovereign command theory. The next general principle of Austinian positivism is known as the separability thesis. Okay, and again, this sounds quite fancy and academic, but in reality, it's very, very simple, just like sovereign command theory. Because what the separability thesis tells us is that it's essentially the assertion that distinguishes positivism, legal positivism, from the natural law theory. Because essentially, what the separability thesis tells us is that law is dependent on nothing else for its existence than the command of the sovereign. Okay, so remember what I said here earlier on, talking about sovereign command theory, that there are no external influences and that it is the sovereign that commands law, and then I also mentioned that it is only the sovereign that commands law, that there are no external influences. Well, this is explained and exemplified in the separability thesis, because what this is telling us is that there is nothing else that law depends on for its existence than the command of the sovereign. So long as the sovereign commands it, that's how law is justified, how the existence of law is justified. There is no concept of justice, there is no concept of fairness, there is no concept of equity, there is no concept of anything like this, or morality as well, if we want to include that and distinguish to natural law, that influences the law. Okay, that is not to suggest that these things don't exist. It is to suggest that these things don't influence law, because it is only the sovereign and the command of the sovereign that influences law. So bear that in mind, because of course John Austin was writing at a time where things like equity existed, at least as legal concepts. Equity existed and has existed for nearly 1,000 years in the common law system. But it's not that they don't exist, or that you can't derive justice out of some legal principles, but it is just that justice, fairness, equity, morality do not influence the law. Austin wouldn't suggest necessarily that there are laws which are not moral or that don't align with morality. It is just that they are inherently distinct. Okay, if they align with morality, that is because the sovereign commands it, not because they have to. There's a prerequisite that they have to align with morality, or that they are influenced by morality. Law is only influenced by the command of the sovereign. So command of the sovereign plus sanction are the core elements of law in Austinian legal theory. And essentially, when we think about this, how do we think about this in relation to the enforcement of law? Because the will of the sovereign is not necessarily the only aspect of Austinian positivism. It is the only influence and the only point in which law is derived, but it's not the only aspect, okay? Because what Austin also does is place emphasis on the importance of law enforcement, enforcing the law. Actually, there's a difference between actually thinking about the law and thinking about what the law is and how it ought to be and how it should be made, and then also thinking about how we then apply that law to real-world situations. This takes us from the realm of the academic to the real world. And there ought to be a mechanism in place, according to Austin, that exists for law to be enforced. And this is, according to Austin, exists in the form of the institutional enforcement of law. So things like the police force, a police system, a judiciary, a military, etc., all of which play their role in applying the law and enforcing the law, because it is the police who do the sort of day-to-day work of ensuring that the criminal law is adhered to and investigating those who do not adhere to the criminal law. It is then the judiciary to then make a judgment as to whether or not the police have been correct in their decision to charge an individual with a particular crime. In certain very extreme circumstances, a state can be put under what is known as martial law, where a military then takes hold and sort of enforces the law as applied by in military situations, in situations of emergency often. So when we combine both this idea of sovereign command theory and the idea of enforcement of law, we get what we believe to be we form the notion of law according to Austin.